This is Conversation in Civics. I'm Dr. Terri Susan Fine. Joining me today is Orlando area high school teacher Stacy Skinner. Stacy.
Hi, Terri. I teach United States Government at William R. Boone High School in Orlando, and I'm also a teaching associate for the Florida Joint Center for Citizenship.
Thank you very much. Part of citizenship is understanding your rights, and so this conversation focuses on the Constitution and the Bill of Rights.
I'd like to gain your insight about those amendments in the Bill of Rights, so it might sound a bit like I'm quizzing you. Tell me about the amendments in the Constitution. How many are there? When have they been ratified?
You know, that's interesting because the Founding Fathers, one of the things that makes the Constitution work is that it created a process for changing the Constitution. Article 5 of the U.S. Constitution includes only the amendment process.
And this is why it's referred to as a living document.
Absolutely, because they understood that as changes arose in terms of the nation growing and who would be living there and what people wanted from government, that there might be a need for amending the Constitution. To date, the U.S. Constitution has been amended 27 times. Now, the Bill of Rights is the first 10 amendments to the Constitution, and they were ratified in 1791. However, the remaining amendments have been sort of sprinkled throughout up until 1992. The last amendment to the Constitution, number 27, was ratified in 1992.
And even though the 27th Amendment was ratified in 1992, wasn't it originally proposed by James Madison?
Yes, Madison proposed the amendment in 1789. This amendment is the amendment that says that members of Congress cannot give themselves a pay raise in the current Congress, or what we think of as the current session. So even Madison understood this idea that members of Congress might serve themselves over what was good for the people, but it took 203 years to ratify.
And it seems to be fairly common knowledge that adding the Bill of Rights to the Constitution was necessary for ratification. Why then was it not part of the original Constitution?
You know, that's interesting because the original Constitution was written by people who believed in a state-centered government. We sometimes call that a decentralized government, and they were leaders under the Articles of Confederation. Mm-hmm. So we have Confederation, decentralized, and state-centered, all meaning the same thing. Mm-hmm. So here were people, many of whom believed that there had to be a federal system, and yet there was a very strong and very vocal contingent who believed that if there were a national government, a system of shared power between the state and the national government that we call a federal system, mm-hmm. They believed that that would then abuse its power over the people. And so there were a group of people that we call the AntiFederalists who believed that without some protections for the people, that the people would not live well under the new document. So the Bill of Rights was actually a negotiating chip, as we might call it. And the Bill of Rights was promised to the Anti-Federalists that in exchange for their support of the Constitution, that the Bill of Rights would be added as the first 10 amendments after the final ratification. Now, just to add one more tidbit, the state of Rhode Island, which had equal power to Virginia under the Articles of Confederation, they were the last to ratify in 1790. So even though we think about the Constitution being finished in 1787, it wasn't fully ratified until 1790, which is why it took until 1791 for the Bill of Rights. Because the Bill of Rights, yes, it was added right after, but right after wasn't right after 1787. It was right after 1790.
See. Now, the Bill of Rights secures individual liberties. Tell me about the different categories of rights within that compilation that is the Bill of Rights.
Well, it's interesting because if we look at the Bill of Rights, we actually see that the First Amendment is its own set of rights. The First Amendment says Congress shall make no law, and it includes 5 or 6 rights. Some people look at the 2 rights pertaining to religion as being one right, and some look at them as being 2.
Because it doesn't say, quote, freedom of religion, end quote.
Not
Which not
at all.
many people stop to realize.
Absolutely. It says the government may not establish a religion, and Congress shall also guarantee free exercise of religion. So when some people think about freedom of religion, they think, oh, that's one right, but it's actually two in the First Amendment. If we look at Amendments 4 through 8, we find that these are what we call the rights of the accused. Some people say it's the rights of criminals, but it's actually the rights of people who are accused of being criminals.
Innocent until proven guilty.
Innocent, right to a fair trial, right to a jury, a right to due process. Those kinds of guarantees are the rights of the accused as found in 4 through 8.
For example, in the Sixth Amendment, it doesn't say, again, just like the First Amendment doesn't say freedom of religion, the Sixth Amendment does not say fair trial. It says speedy and public trial, impartial jury right to an attorney, and it is that in concert, that set of rights that creates the fair trial.
And interestingly enough, as much as those Bill of Rights, those rights in the Bill of Rights were deemed to be so critically important, wouldn't you know that over 200 years later, we're still arguing over what does it mean to be speedy or impartial? What does it mean to have counsel? So we find that these guarantees are constantly being examined and re-examined because of how trials go, how due process goes, and those kinds of things.
It's my understanding, and it comes up often in conversations, that a predominant number of cases before the Supreme Court are related to Bill of Rights issues.
Absolutely. And they're related to Bill of Rights issues for all kinds of reasons. One is that if we look at that First Amendment, those are fundamental ways in how we lead our lives, right? The fundamental, right? If we look at even recent U.S. Census data, 90% of the American public says that they are a member of a religion. So 90%, at least when asked by the U.S. Census Bureau, say that they are exercising their free exercise under the First Amendment.
Or the various forms of freedom of speech.
Absolutely. And what we've also found, of course, in 200 years, we find that speech is not always some words that come out of a person's mouth.
Symbolic speech.
Right. Speech can be something that you wear. Speech can be a way that you move your body.
Expression.
It can be all kinds of things. So those are the things that we do on a daily basis. We read newspapers. We take advantage of information sources. We talk to our neighbors. We interact with our public officials.
And with the advent of technology, there's such an interlacing of freedom of speech and freedom of press.
Absolutely. And we also find, particularly now, that because of the technology that you mentioned, that there are more and more people who themselves are becoming the press, right? We hear about these things called blogs or web-based logs, and we find that, wouldn't you know, people themselves are reporting their own experience and broadcasting it out through the internet to the world.
And on that note, how does the Bill of Rights safeguard and limit individual rights?
Well, it's interesting because when we talk about safeguarding, meaning that these are certain rights that are guaranteed. How do you guarantee something that I just said a few minutes ago was so vague that we're still arguing about it over 200 years later? You safeguard it by using what people call the balancing test. The balancing test basically says that if you had a seesaw, just to give it a metaphor, if you had a seesaw and one end of the seesaw was the public interest and the other end of the seesaw was individual freedom or individual rights, basically we protect and guarantee individual rights when the U.S. Supreme Court makes a determination, or other lower courts as well, that indeed the public interest is not harmed or it's not threatened sufficiently enough to deny that person their individual rights. So on this metaphorical seesaw, that's sort of a point for individual rights.
So I have my rights insofar as they don't infringe upon someone else's individually or the common good.
Absolutely. And yet, if it turns out that somebody's behavior right? The First Amendment is ultimately all about behavior. 4 through 8 are all about people accused of doing certain behaviors.
Yes.
So it's all about individual action. If it's believed that a person's actions threaten the public interest, then those actions can be limited. The way that we understand this the best is if somebody says the word fire in a crowded movie theater. Now, if I'm sitting with a friend of mine watching a movie and I turn to that person and I say, I'm afraid I'm going to get fired, no one's going to start screaming and running away. But if I run to the front
and you yell, fire,
and I yell fire, I use my teacher voice, right? And I scream fire, and I sound panicked.
You're going to create a hazard, and it's a public safety hazard.
Now, why do we use the phrase movie theater under those circumstances? Because it's a dark room.
And it's a public setting.
People can't find their way out. They have no information. So you're causing a threat. That's when you limit individual rights.
Is there ever a time when the government can limit individual rights?
Oh, absolutely. The government limits individual rights all the time. And what we find is that those individual rights tend to be limited even more when the United States either is at war or we are in protracted conflict or ongoing conflict with other nations in the world. So what we find is that even if the Supreme Court makes a decision, it's not an absolute decision, because indeed that decision has been interpreted in ways during wartime versus during peacetime, that if there's more public threat out there, then there's going to be more limitations placed on individual rights than if there is less public threat.
And we see that in some key controversial issues today.
Absolutely. One of the things you raised was symbolic speech. And there was a case going back, about 12, 14 years, about the mid to late 1990s, that where somebody wanted to burn a United States flag.
Texas v. Johnson.
Texas versus Johnson, right, 1988. And the Supreme Court agreed that because he did it outside, because he burned a flag outside, that he did not cause harm or threat to the public, and therefore flag burning was deemed to be a form of free speech as guaranteed in the First Amendment. Okay, to recap briefly, we talked about the Bill of Rights, amendments to the Constitution, and how the Constitution both safeguards and limits individual rights. And that's Conversations in Civics. I'm Dr. Terri Susan Fine.